Hi everyone, LJ Aguinaga here with LJ Realties, and this week we're going to do a slightly different segment. I have Mr. Michael Bergman here as a special guest. He is a lawyer who will be talking to us about latent defects. You may have noticed the last couple of segments I've discussed legal warranty, sales without legal warranty. I figured it would be super important to get an opinion of a lawyer because my first recommendation was go speak to a lawyer whenever anything like this comes up. So Michael, thank you very much for joining us.
Thank you, my pleasure.
The first question is always, okay, I have a problem with the house. I do have legal warranty, so I'm going to have some sort of recourse. What do I do now?
Before you even get to that point, when you're purchasing, you need to do certain things. You need to hire an expert to inspect the property. You need the inspection to be complete. You need an inspector who's competent. Don't use a cheapy inspector. You don't want an inspection where your report, the written report, is simply 3 pages of boxes that have been ticked off. You want a written report on all the mechanical functioning of the property. Then you need to sit down with your agent, ask questions. Has there ever been a problem with this property? Has there been a leak? Has there ever been some sort of environmental contamination? You need to sit down with the seller, ask the same questions. Now, why do you need to do this before you even buy? Because one day when you have a problem, and latent defects are the most common cause of court cases in real estate matters, you need to show that you were diligent. If you haven't done these steps properly, then when you go to court, the judge is going to be very upset. And he might say to you, or she might say to you, you lose, and you're not going to be very happy. So preventative measures are the first step. You have an obligation to do your due diligence.
Excellent. So I completely agree. Preventative measures are always the best measures to take. Luckily, we are usually diligent buyers. We do thorough inspections. So let's assume that the buyer did take the necessary steps during the purchasing process to get the inspection done, review a seller's declaration, ask any necessary questions on the seller's declaration that they had questions upon that were unclear possibly. Now, we still have the issue. What would be the next steps?
Next step, you find there's a problem. You need to act on that problem right away. You cannot sit on it. You can't sit and wait a year or even 6 months. That will be held against you. As soon as there's a problem, you send a letter. If you send your own letter, send it by registered mail. If you prefer to hire a lawyer, which is a better idea, have the lawyer send the letter right away. If you wait and don't send the letter and do the repair first, that will be held against you also. You have to give the seller the opportunity to come and look at the problem and then fix it if he or she is willing to do that. So the letter has to go right away.
So that makes sense. The letter that you're discussing right now, I believe is called demand letter. In French, you may have heard of it. It's a mise en demeure. So we use both terms in Quebec. It's just something you need to watch out for. So you sent the letter out. What about getting professionals in to decide? I believe it's important to decide when the damage happened. Was it present at the time of the sale? Talk to me a little bit about that.
Well, the damage must have occurred before you bought it. If it occurred after you bought it, you can't hold the seller liable. The idea of a latent defect is it's hidden from you in the property before you bought it. In fact, it could have been hidden from the seller. The seller may have no knowledge of the defect, but if it was there during his ownership, he's still responsible, even though he may have done nothing wrong. In fact, the previous owner could be responsible, and the previous owner before that could be responsible. So you could end up suing more than one person, or you may sue the seller and he may countersue the previous owner.
Okay, so now we've gone to the demand letter. We have reached out to the seller. They have come to inspect the problem. They've decided they are not going to repair. They're saying that they're not liable for it. It is not their responsibility. What would the next steps be?
You need to hire an expert to evaluate the damage. What's it going to cost? Is there excavation? Is there invasive measures that are needed? If it was a flood, for example, you may have other claims. You may want to contact your insurance company, but your insurance company may cover flood. It won't cover the cost to repair the property for a latent defect. Then with your lawyer, a lawsuit will be drawn up and sent by bailiff to the seller, and he or she will have to then engage their own lawyer.
Now, during this process, sometimes it's something that makes the home either unlivable, you might have to leave the home, or you might actually want to repair it right away in order to prevent mold or things like this from happening. What would be your recommendations in this case?
First step, move out if you have to. Those charges should be assessed against the seller. If you need to do urgent repairs, you've got to get your letter out right away. You've got to at least give the seller 2 or 3 days to come look at the place and see if he or she will fix it.
Okay, and generally speaking, let's say at this point they're not fixing it, you have done the repairs, now we're in a court battle. How long is this going to take roughly?
Well, that's the unfortunate part. A good court case is going to take 2 years, 3 years to complete. Now, if you're lucky, the case will get settled. But it may not get settled right away. It may get settled in the days preceding the trial. It may get settled along the way. Settlement is a compromise, so you have to be ready to put, as they say in French, water in your wine. And if you want to go all the way, if you don't like watery wine, then you're going to wait. And in the meantime, your house may or may not be completely fixed. You may or may not have all the funds to do the repairs. You may have to wait, and it's a headache. And going to court is not a done deal. It's not like television where everything is black and white. Everything takes 1 or 2 hours on TV. Let me assure you that most television actors who portray lawyers should be disbarred. That's not how the real system works. It's a slow, tedious process in which there are long periods of time when nothing is going on.
Okay, so if we are sitting through this process and the buyers in this case don't have the funds required to either repair or go through these things, what would be the options available for them at that point?
They're either going to wait until the result of the court case, they're going to raise money by way of a hypothec or mortgage, they're going to borrow money to fix it, or they're going to grin and bear it.
Okay. Now, another scenario I've heard about recently is somebody's dealing with latent defect, they've done the repairs, they've started the legal battle, it's going back and forth. At this point, though, the house no longer meets their needs and they want to sell it so they can move on to their next home. What is the implication of there being currently a legal battle happening during the time of the sale?
Not a good situation for the buyer who is now becoming the seller. How many people are going to want to buy a house at the price that you would want when there's a legal battle over latent defect? Because first of all, you have to tell your purchaser that there's a legal battle. Then you need to tell the purchaser what is the problem. Was there flooding? Were there cracks in the foundation? Were there environmental problems? And heaven help you if there are environmental problems, because that means extensive excavation of the soil and remediation processes. So basically, you're looking at selling it at a fire sale. Unless you're really fortunate and somebody wants the property because its other attributes are so amazing, or they want to demolish it and rebuild completely.
Interesting. Okay, so all in all, this is definitely something we're trying to avoid at all costs. Now, we've mainly been focusing on the buyer who's dealing with a latent defect. What do you have to say about a seller who receives a demand letter after selling their home?
If you're a seller, you receive a demand letter, now you have a predicament, because you may have known there was a defect and sold it without advising your purchaser. Then your best bet is to negotiate through a lawyer some type of settlement. If you did not know there was a defect, you have no idea, you don't know what this purchaser is talking about, maybe they're imagining things, you have to send an inspector right away to look at the problem and verify if it's for real. And if it is for real, then you have another problem, because the law says you're liable even if you didn't know there was a defect, if the defect was there when you own the property. So the only benefit to you in the law is that you will not be held for consequential damages, but you will be held for the repairs.
Okay, so very serious in that regard as well. If you were the seller and you receive a demand letter, first step would obviously be to go check it out immediately, find out what's going on, get quotes as well as on your end. If you did know about it, I mean, you may have acted in bad faith, unfortunately, and that's what we're trying to avoid at all costs. But obviously, coming to a settlement seems to be the best option there. If you didn't, it's just part of the game, unfortunately. If you were unaware, sometimes there are things that are happening beyond your knowledge, whether that was in the attic or another space that was invisible to you, and that is one of the consequences potentially. So it is super important to do all of your regular maintenance, to stay on top of your home, to check the nooks and crannies, if you will. Go into the attic at least once a year to verify that everything's functioning properly. Do you have any other recommendations for people dealing with latent defects?
2 things. Before you sell, hire your own inspector. Let your own inspector for you, the seller, look at the place. It's worth the investment. That's number 1. Number 2, you get a demand letter. Most demand letters find their way into the garbage. That's not a good idea. Don't fold it up into a paper airplane and shoot it in the air to see how far it can fly. That's a bad idea. Take it seriously. Especially if it's a lawyer's letter, but even if it's just a registered letter. Take it seriously, take the steps, spend the dollars to get the inspection done, sit down with a lawyer and discuss it.
Okay. Well, there you have it, folks. Thank you very much, Maitre Michael Bergman. Really appreciate you coming in today to talk about latent defects and steps to take. I think it's super great, especially following our legal warranty segments. We look forward to seeing you guys next week and can't wait to bring more special guests to discuss different topics for you guys.
Thank you very much.